Welcome, everyone. I'm Frank Kearney. As you know, I'm a attorney here in Washington, D.C., and we handle serious injury cases. So for people who are hurt at work or on the roads or in a hospital or denied their long-term disability benefits, due to an injury or illness, those are the kind of cases that we handle. We sue insurance companies all the time. But one thing that we certainly don't do, and I don't do, is practice outside of our areas of expertise and our specialties. And we're always looking for other professionals to recommend and to provide value to all of our clients and our friends who are watching. And I want to welcome all of you as well. Today, we've got a real special guest, Adam Moskowitz, and Adam is a lawyer practicing in both Maryland and DC, who practices in the areas of wills, trusts, estates, and he's going to tell us, a lot about that. I think this is really important at this point in time, especially because, as you all know, with coronavirus, none of us are promised tomorrow. So we shouldn't put things off until tomorrow. We don't know what's going to happen with our lives, with our businesses, with our finances, with our families. So welcome, Adam. How are you?
Thank you. Thank you for having me. Happy to be here. I'm doing well as can be expected. It's certainly different times for everybody, but in the field of trust and estates, it's been very busy. People are finally starting to think about this, and they also have the time being at home, maybe with a spouse, to think through and discuss these things. So we've had a lot of movement, and I've been happy to work with and help a lot of people.
That's great. Tell us a little bit about your backstory, Adam. I know that was a really brief introduction I just gave you, but what is it you do? How did you get into it?
Sure. So I went to law school at George Washington University, and while I was there, I spent a lot of time trying to figure out what type of law I wanted to practice. My first summer in law school, I worked for a general practitioner in Friendship Heights, Maryland, who introduced me to wills and trusts, power of attorney, medical directives. And very quickly, I realized that it was something not only I enjoyed helping people with, but that I had some talent in. And so then I moved on to work for a New York State Supreme Court Appellate Division judge in Manhattan the following summer. And then I started working at the firm I'm currently with as a law clerk, where they specialize in trust and estate planning and administration. So when I graduated, I joined as an associate with the current firm. And since then, I've just spent a lot of time working with individuals, couples, families, and trust and estates became something that I just really am thriving in. And I like that, even though sometimes it can be controversial and adversarial, I get to help people every day. And so after I graduated law school, I became a partner after a couple years. And now I'm essentially running my own practice here. And it's been going great.
And that's really what it's all about, I think, is, like you said, helping people every day and being able to do that. And especially in really impactful ways with really serious, and important issues that they face, right?
Absolutely. I mean, that's part of what gets me up in the morning, is knowing that I really get to make a difference. It's just genuine and true. I get to make a difference, and people, I can make them happy, right? And so they get some peace of mind, and they realize that, wills and trusts are often a little more involved and complicated than they might think after they go to LegalZoom. I'll often have clients call me and say, "Hey, I did my will on LegalZoom, but it doesn't seem to have everything. And I heard about these taxes and those issues and these family matters and this asset protection, but I don't see any of that there." And I always tell them, I say, well, if you go to LegalZoom, go to the bottom of the page, and there's always that small black print type that says, if you actually want to work with a lawyer, that'll cost extra. So if you want to speak with a lawyer, that'll cost extra. And often people don't know the questions to ask. And so if you don't have someone to have that dialogue with, an attorney that has that experience, you're going to miss out on things. For example, LegalZoom isn't going to tell you that if you leave your assets to anyone other than an immediate family member in Maryland, in addition to a potential estate death tax, there's an inheritance tax that is a 10% tax to anything you leave to a niece, nephew, friend, cousin. They won't talk to you about that. They also won't do a lot of sophisticated trust work as far as making sure that you avoid probate while also making sure that your family members can pay for your final expenses, your final taxes, make sure your final tax return is done, and make sure that everybody's happy and that there's no fighting. And that's what causes the extra legal fees, is when things are not organized on the front end.
Mm-hmm. Yeah, no, that's a really good point. I think, look, with legal services or with anything else, I mean, you get what you pay for, right? I mean, that's pretty common throughout this country, I would say. Let's talk for a second about healthcare power of attorney. What is a healthcare power of attorney? We get a lot of questions about that. Like, what is it? What does it do? Why would someone need one?
And now especially people are starting to think about that. Healthcare power of attorney comes in many different forms and names. You may have heard healthcare power of attorney, medical directive, living will. I don't like the term living will. I think that it confuses my clients and other people with their actual last will and testament. So I'll typically call it a medical directive or a healthcare power of attorney. And effectively, what you're doing there is you're making your wishes known if you can not make decisions for yourself. I will often get clients who have concerns and say, well, whether it's the healthcare power of attorney or the financial power of attorney, I don't want this person making decisions for me if I'm okay. And that's not what it's for. It's only if you cannot make decisions for yourself, it allows the doctors to interact with the person that you choose to make those decisions for you.
Mm-hmm. I see. So, yeah, that's something I take it you would use if you suddenly were ill or were injured and you couldn't, I guess couldn't decide whether, you should be on a ventilator or had some other, serious healthcare concern.
And correct. That's the real concern, is that if you put it off and you do end up in a situation where you have dementia or you're in a coma and you cannot make decisions for yourself, at that point, you no longer have the capacity to sign a document and give someone that right. And the only way to have someone appointed as your guardian to make those decisions is to go through the court. And the last thing that we want is for your healthcare decisions to either go through the court or to really be in the public forum. I often tell my clients, or remind my clients about the Terri Schiavo case. And what happened there was that Terri Schiavo was, she was completely incapacitated. She was on life support, and there was no reasonable expectation of her recovery. And the doctors asked the husband whether to continue life support or not. And the husband said, it's time to let her go in peace. And her parents said no. And because she did not have a medical directive or healthcare power of attorney, the doctors didn't know who to listen to. And her healthcare became national news. And so one of the things that I pride myself on is I can keep my clients' healthcare out of the national news just by having that in place.
Well, that and keeping them out of court, right? I mean, because if you go to court for something like this, when you need the medical treatment, we all know how slow courts move, and especially now when they're closed.
Courts are essentially non-existent right now.
Yeah, and two, it's expensive, right? I mean, it's much more expensive, I would take it, to to be in court over something like this, to be litigating this, or to be trying to get this done in front of a judge, versus to sign the paperwork well in advance of when this happens.
Even if everybody's on the same page, just to get the court to sign off and go through the due process of getting someone appointed to make that decision, that's one thing. What about if you were incapacitated and your spouse and your parents both disagreed on what to do? The legal costs skyrocket at that point if it's a contentious matter. So, sure. For a couple $100, it's worth getting your medical directive in place.
Yeah, it sounds like it. And you just mentioned the famous Terri Schiavo case from some years ago that was all over the news. Right. And, you always hear also, Adam, about famous people who die without a will. And then what happens to them, and what a big deal it is for their heirs, for their families. Why? I guess one, why does that happen? And two, is that just celebrities, or like do regular people, benefit from having a will as well?
Sure. So celebrities are obviously more pronounced in the media and society, but statistics are telling us that about 70% of people either don't have an estate plan or they don't have an estate plan that's proper for them. And it's a really big problem. I always say I never meet someone I can't help. Dying without a will is often going to be a problem. There are exceptions. There are certain cases where if a couple maybe doesn't have a tremendous number of resources and one of them passes away and most of their assets are titled jointly, or they're named as beneficiaries for each other on all of their assets, you might not have a big problem. Okay, if there's a surviving spouse and the surviving spouse has access and knowledge about the assets, how things work. For some of the older couples, what we've seen is that historically the male was in charge of the finances and dealing with the CPA and the financial advisor. So we do have some instances where we see some elderly couples where the man passes because typically the females outlive the males. I guess they just have better genes or they eat better or something. But they typically they will outlive us. And then they come to me and they say that they don't know how to deal with wrapping up their husband's estate. They don't know who the financial advisor was. They don't really know the CPA. They've never reviewed the tax return. In fact, sometimes they don't even have check writing authority. So some of what I do is not just drafting a will for you. It's really organizing your affairs up front. There's always the ability to do it on the back end. But if things aren't organized up front, it's often multiply more expensive on the back end to take care of it then and to handhold a surviving spouse through the process. Now, if we're talking about more sophisticated tax issues, you certainly want to work with an estate attorney or else you can really get hit with a big tax bill or your estate will. Okay. And then also if you have minor children, there's also a lot of pitfalls if you don't have the proper type of will or trust in place.
And you're right. I mean, when you talk about the grief that a surviving spouse has, this is just going to kind of compound that and make this more difficult to do, after the fact, after the first spouse passes away, no matter what the relationship, whether they had, total joint, authority over everything and both knew all of the family finances and what have you. I imagine that's got to be really tough.
It is. There's a huge emotional component. Sometimes I joke that I'm a little bit desensitized to it because I deal with it every day. But I really do make a point of it to understand, the emotions of my clients. Sometimes there are clients that they're very hot to trot, gung-ho, and they say, I want to wrap this up, either because they're emotionally stable or because they know for them doing this, doing what their predeceased spouse wanted might make them feel better. And some people just don't want to, they might just wait a long time to even deal with these things. What typically happens is if someone passes away and they have assets titled only in their name, those assets must pass through probate. So if something happened to you and you had a checking account with a lot of your money in it and it's just in your name and your spouse goes to the bank will not let them access those funds. And so they will have to go get an attorney to get themselves appointed by the court as the personal representative or executor of the estate.
Right. And then again, that takes up time. That's a little more expensive. That's, the money I assume is frozen, can't be used until that happens, whether it's checking accounts, savings, investment accounts, property perhaps, if it's only in one person's name.
That's right. And even if we're talking about, because I mentioned older couples and maybe middle-aged couples, but even with the youngest of couples, people who are just married, maybe 20s, 30s, and we've spoken about this before, but typically, especially in this area, younger couples, if they own a piece of real estate, they've had help from at least one side of the family. And so we have had issues where we've either planned for, or this has actually happened where a young person has passed away who was married, and eventually maybe they move on to a new spouse and they bring those marital assets with them, but their predeceased young spouse maybe received $250,000 or $500,000 from their parents to purchase the home. And so we have these issues that if you don't plan, even with young couples, we think, oh, well, they don't have that much money. But maybe the wife's parents gave a lot of money to purchase a marital home. And if she passes away, we can often plan and protect that money so that it stays in that part of the family. Maybe the house is sold, or the surviving spouse has a life estate. But there's a lot of issues that people really don't consider. And until we sit down and have these conversations and discuss them, people don't really think about it.
And that's a great point. I think representing, individuals, I mean, just like we do, what you really come to see as a practicing lawyer is that every person and every family are different, and they have different needs and different things that you need to do to help them make the best decision for themselves when it comes to this. Adam, I'd say too, while we're on the subject of wills, when should people get a will? And then also, one of my questions is how often should you have it updated then?
Sure. That's a good question. I think that really everybody should have a will. I think that if you are a young person who's single, maybe with not a lot of resources yet, I always recommend financial power of attorney and medical directives. Because again, if you are incapacitated, you won't be able to sign those. A will might not be completely necessary. Something simple might be in order, but it's always good to start that relationship with your estate planning attorney, because then you have that. They are your go-to kind of family estate attorney. And then when things happen, you can grow with them, and you can, as your life gets more complicated, you can add to it. I think certainly anyone who's married, anyone who owns a lot of assets, anyone who has children, especially minor children, need a will, potentially a trust. And then as far as updating the documents, I always say if there's a birth, a death, a marriage, or a divorce, not just with the people who sign the documents, but anyone related to the estate plan, whether it's a family friend you've named as a guardian of your minor children, or a trustee you've named for a contingent trust for your children, or even grandchildren. If anything happens there, you want to update. Okay. But also I recommend every 5 years, take a look at your documents, make sure they still make sense to you. Even if they are the correct documents that you need, it's always worth getting a refresher on what they actually do, what some of the language means. There's often going to be a lot of legalese in those documents, and you want to make sure you understand them. And I'll make one last point, in that we've had some pushback from banks recently, maybe from other financial institutions, but definitely from banks, where if you don't have a relatively recent financial power of attorney and you walk in and say that you are a financial power of attorney agent for someone, and even if you have an original document, you may get some pushback. They may call it what we call in the legal world as stale. And they will say, well, we don't know for sure that this 15-year-old power of attorney document is still the intent of the person who signed it. We also don't know that this hasn't been superseded by a new financial power of attorney. And so unless you have something that's really only a couple years old, you may end up with problems for financial power of attorney. And if you have maybe a more elderly couple and one of them is having issues, whether it's dementia or Alzheimer's or something else, you really want to make sure that both spouses could act for each other, even if they're not an owner on an account. And that's what financial power of attorney allows you to do.
Yeah, and I think that's a great point, because anytime you're dealing with an institution like a bank, an insurance company, or what have you, one, they're reviewing this stuff on an ongoing basis all the time for changes in the law, because we all know that our legislatures in DC, Virginia, Maryland, they're changing stuff all the time. We don't, there's no reason we would necessarily even know about that or catch that. But the second thing is, you want to avoid a fight with a bank or an insurance company if you can. And I take it one of the ways to do that is to make sure that, at least your financial power of attorney, which is different than a healthcare power of attorney, I take it, is up to date.
That's right. There's no question about that. That's where we find most of the issues. It also happens to be where we find the most fraud, again, because people they do have relationships that evolve. They might have named someone previously, maybe one of their children, and that child becomes, a ne'er-do-well of some sort. And then the other child is maybe the person who's more proficient with finances, and things change. And we've actually litigated cases where there was fraud, where someone was named as an agent in a power of attorney, and they used that to have a negative impact on their parents' finances. So you want to be very careful.
Great point you made too, I think, about establishing a relationship, even, if you're a young couple or you're a young person,
Right.
With an estate planning attorney, with a specialist who can kind of help you get started with this, because you're right. I mean, what we've seen in our relationships with clients is, you want to have that relationship with a lawyer where that's your lawyer for life. That's kind of your family lawyer, because even though we don't handle DUIs, for example. If your, son gets a DUI, someone calls me, I can find a good lawyer for you.
That's right.
And and I'm sure you're the same way, right, Adam?
Oh, I get calls, for my clients all the time. And they basically say, hi, I've had a DUI, or I'm starting a business, right? Or I'm buying a piece of real estate. And they want that referral. I mean, it's funny because lawyers are people too. And so, people think of us as robots sometimes, and we get a kind of a bad rap, but they say, oh, I'll just call a lawyer and they'll do a bang up job for me. A+, I'm sure they will. I'll pay for it. It'll be just fine. But lawyers are people too. And what I typically find is not only do I have a better effect on the documents when I'm working with people that I have a relationship with, because you understand the idiosyncrasies of their family and you understand where they're coming from. You already have a lot of information on them, and building upon that makes things easier. And I think it creates a more effective estate document.
Sure. And they're more comfortable to discuss. I mean, some of these are relatively intimate, personal, financial, medical, health, and family issues. So I think once you have that relationship, they're more comfortable in talking to you if they've met you a few times or over a few years.
Not to mention, if someone calls me and says that they've had a personal injury matter, or they want to start a company or any other type of thing, if it's something I can help them with, I know, like you said, I know someone who can, might be you. And if I refer something to you as a friend who I know can do a quality job with this work, not only are you beholden to the client and you're going to do a good job, but you're also beholden to me as their family attorney, because you know that I know what's going on, and also you want to do a good job because that will entice me to send more to you. So I think that just from a kind of a psychological level, having that relationship can just have all of these extra benefits.
Right. No, absolutely. And I think it's important, and unfortunately a lot of lawyers aren't like this, but it's really important to be, not just a lawyer, but a counselor for the people who. And in fact, Adam, I know in my business, like, choosing the right lawyer is really important. Like, the insurance companies know, who the real trial lawyers are, who handle catastrophic medical malpractice cases and what have you, and they know who doesn't. But you can often tell it early on in the process in like a serious injury case. Now, in your business, I would take it that that's very similar, that you need a specialist for these, for estate planning documents.
Sure.
But I also would think that people may not know or find out until years later that the documents weren't done properly, or their interests weren't taken into
That's
account.
100% correct. And sometimes it's even too late to fix it at that point. Fortunately and unfortunately, drafting a will, doing estate planning is something that a lot of attorneys feel like they can figure out. And they say, oh, you know what? I can work with a document. I can make this happen. But I promise you, unless you're doing it every day, unless you're really thinking about it, staying up to date on the tax code, there are things that there's not enough time in the world, in addition to your actual life, dealing with your business, doing your type of work, there is nothing that can prepare you to do the job that is necessary for the clients. Again, I'll go back to my original comment about, yes, if you have a very, very, a truly simple, and most documents are not simple, even though people think they are, a truly simple situation where you have a young single individual with not a lot of assets. If you have another attorney, can they help you with a document? Sure, I think you'll be okay. But anything other than that, you really have to understand what's out there. For example, recently there was a law passed called the Secure Act, and it changed how retirement planning is done, as far as if you have a retirement account and someone inherits that retirement account, what are the rules? And it used to be that if you inherit a retirement account as a non-spouse, that money will continue to grow income tax deferred with small required and minimum distributions coming out up until a certain age, okay, or until you pass. But that changed. The government decided that they were not going to let the inherited retirement accounts grow income tax deferred for that long. And so now, unless you are essentially a spouse, a disabled person, a minor child, or a sibling that is no more than 10 years younger than the decedent, there are completely new rules. And one thing that we're planning for is, if you have minor children, you want to make sure that your retirement account interest, if it doesn't go to your spouse, if it goes to your minor kids, that it goes through a special conduit trust to allow that money to grow income tax deferred as long as possible, with minor children being one of those exceptions that allows for that. And if it ends up being left to the child directly, a child who's under 18 cannot inherit an asset, and that asset has to go to a guardianship estate, and that will have a big negative tax consequence. So, someone who does personal injury, who's trying to put together a simple will, won't understand those things. They haven't read the Secure Act and the tax code and understanding how that works. Same thing in Maryland, like I had mentioned, the inheritance tax. Unless you know about it, you don't know about it. And so you want to make sure that you're talking to your clients about those things.
Yeah, and I think that's a great point, Adam. I mean, I've been a lawyer for 25 years now, and I know a lot of stuff in my practice areas, right, but I had no idea about that. And so just like, a doctor, someone in sales, someone in construction, a business owner, what have you, that person's focused on what they're doing, in their business and their life. There's no way to keep on top of all of the tax law changes, all of the various, changes that can affect, their spouse, their kids when they're gone.
That's right. It's a big misconception that a lawyer is a lawyer is a lawyer, and that we all can do anything. Could we all do anything? I don't know, maybe, but there certainly is something to specializing. And unless you are specializing, it's really, really impossible to keep up with everything that you would need to know.
Yeah, no, great point. It's not something, like you said earlier, that you can just download off the internet. Adam, we have a couple of questions. A couple were submitted beforehand.
Great.
And a couple of people have sort of raised their hand, but here's one. Does a single person need life insurance to take care of outstanding debt, like student loans or mortgage, if they don't want their parents to carry the debt?
So that's a great question, because it brings up one of the biggest issues that people bring to me. Okay. If someone has debt and they pass away, no one else is responsible for that debt unless they have, they are otherwise a cosigner on that debt or a guarantor on that debt. So if someone passes away, and even if you're named as a fiduciary, the executor or personal representative of the estate, never, ever, ever use your own personal funds to pay for a decedent's debts. So does a single person need a life insurance? Sure, in some cases, I think it's worthwhile. Maybe you're just getting a good premium in place, and there's other good reasons to have life insurance. But to pay for the debts, not necessarily.
Okay, that's a good one. Here's another one that's along those lines. Will a divorce attorney be able to handle changes in estate status and beneficiaries, or will a divorcing couple need two attorneys?
So that's an interesting question, because as you know, as a lawyer, there's a lot of ethical rules. And I'm sure that you go to sleep every night and you read those ethical rules and you're completely up to date on them, like I am. But essentially, when I represent a couple, they sign a waiver in my engagement letter that says that we don't foresee any issues here currently, and I can work with you together. Okay. But what that also means is that if there is a divorce, I really can't work with either one. because all the attorney-client privilege and confidentiality was for them as a couple, not for either one of them individually. So often, if there is a divorce, a couple will each have their own divorce attorney, and they may even have their own estate attorney, unless they sign a waiver. Maybe one of them really wants to stick with me as a client, and they get their spouse during maybe the divorce negotiations to say a condition of the divorce decree is going to be that I'm allowed to continue to use Adam for my estate planning.
Okay. And here's a related question. It just so happens it was submitted in advance. I won't say the person's name because it sounds like it's sort of a future tense. If I get divorced, do I need to change my beneficiaries, or does my divorce take care of that? So I assume it means, with your with your will, maybe your life insurance, other things you would need a beneficiary for, obviously.
So to a certain extent, the final version of the settlement of the divorce agreement, right? Whatever you settle on, to a certain extent, that will take care of what your rights are, what your assets will be, and it's integral, very, very important. From a practical perspective, if you agree that the beneficiaries should change, maybe the kids become the beneficiaries instead of that spouse, or you're allowed to add a new spouse as a beneficiary on certain assets but not others. Just because you have the right to make those changes doesn't mean that you don't have to make the changes, because if you have the right to make that change and you don't make the change, maybe your ex-spouse is still entitled to that. We had a case where essentially there was a divorce and the house was owned by a couple, and there was a right of survivorship so that the surviving spouse at the time would get the asset. And then the divorce decree, the husband had to move out, and there were some other legal issues there, but essentially they never changed how it was owned. And so many years later, one of them passes and they leave the house in their will, but the will doesn't mean anything at that point because they had still kept the ex-spouse as a joint owner on the property. And so that person inherited it, even though the predeceased wife had the right and the power to change the title on the property. She just never did. Right. So ex-spouse ends up getting the asset.
Okay. And I assume that would be true for like life insurance. If, your beneficiary was your former spouse, then right. You died. That's who the beneficiary is.
That's 100% right. There are some protections for a current spouse. So if you're in a second marriage and you're concerned about being completely disinherited, and if there's no prenuptial agreement, you are entitled to what's called an elective share. So you can never be completely disinherited unless there's a prenuptial agreement in place. So some of those assets might be called back just to make sure that the current spouse gets a percentage. It's usually about a third of the assets. But otherwise, you may not be entitled to anything.
Right. But again, that's something that you can take care of in advance, right? So
that's right.
Why put yourself through that?
Most of the problems that I end up dealing with for people and helping people with are just things that could have been done easily ahead of time. It really is, do you want to organize yourself before you pass, or do you want to have someone else organize for you? Think about like packing up your house. Let's say you're moving, right? Do you want to pack up your house yourself, box everything, you know where it is, you can organize it in your new house, or are you going to let a packing company do it for you? Okay, and then it goes to the new house, and it's a lot more work on the back end. You don't know where things are. It might not be organized. Things might break. So that's really how you want to think about it.
Yeah. Here's another question we got. You kind of touched on this. Can I pass on my retirement account to my son? Do I need a will to do that? He's an adult and I'm not married. So I assume it's just one adult child.
That's a great question. So as one adult child, if you're not married, just name the child as the beneficiary, as the primary beneficiary on the retirement account. You can add the child as a residuary beneficiary in the will. That just means that they get everything that's not otherwise designated, so that if there is an issue for some reason, there wouldn't be, it would still go to your child. But I would just name your child directly on the retirement account. And if your child survives you, that asset will avoid probate.
And that's a great lead into a next question who just popped up from one of our participants or viewers. I hear a lot about probate and it sounds like a negative thing. Can you give me some quick tips on what probate is and how to avoid it?
That's a great question. And if I could get in front of everybody in the country, I would basically explain this to them, okay? Because this is where a lot of confusion and fighting comes from. So the way I describe it is that everybody has two types of assets as far as I'm concerned. They have assets that have direction when they pass away, and they have assets that don't have direction when they pass away. So if you have a life insurance policy and you name your spouse as the beneficiary and you pass away and your spouse survives you, that asset has direction. It knows where to go. There is a living person who is the named beneficiary. If you and your spouse own your house together in what's called tenants by the entirety, but it's essentially joint tenants for married couples, and it has a right of survivorship, if you pass away, the asset knows where to go. It still has an owner. Your spouse then becomes the sole owner of the property. Okay, so those types of assets have direction. But let's say that you have a checking account in your own name and there's no beneficiary listed on there. Okay, you pass away, the asset doesn't have direction in and of itself. It doesn't know where to go. It doesn't have an owner of record. It doesn't have a beneficiary designated. Same thing if you and your spouse own your house together and both of you pass away, there's no one else on the deed. The asset doesn't know where to go. There is no owner if you just look at that asset in a vacuum. Mm-hmm. So when assets don't have direction, they go to purgatory, which by alliteration we call probate. Okay, so all the assets that don't have direction go to probate, and the will, this is very important, the will is what gives direction to assets in probate, but it only gives direction to the assets in probate. Okay, so if you and I are brothers and our parents name us as 50-50 beneficiaries in their will, but they've named you as a beneficiary or joint owner in all of the assets, and those assets have direction when our parents pass away, and you get them because they are directed to you, it doesn't matter that I'm a 50% beneficiary in the will, because the will only directs the assets that don't have direction and go to probate. So I'm essentially disinherited even though the will says otherwise. And that's because when people don't understand that, that's where the fighting comes about.
Sure. And you hear that a lot with especially with elderly folks. They'll make an adult child, they'll put them on their checking account or their savings account to make it a joint account. And I assume in that situation, when the elderly person dies, that money just goes to the son or daughter who's on the account.
So that's another great point. So that actually gets a little bit complicated. If an elderly parent adds one of their children as a joint owner for convenience, right, to make sure the bills are paid, etc., and then the parent dies and the child goes to the bank with the death certificate, the bank will immediately convert the account into ownership by the surviving child. So there are some laws in some cases that say that if it's really for convenience and it was the parent's money, that money should still go to the estate. But then it's still an uphill battle for the other children, surviving beneficiaries, to say that was only for convenience. Then they have to prove that and get it and go to court and litigate that. Right. So it's really bad. So if you do need a child to assist you with your assets, the better ways to do that are to either name them as your financial power of attorney, because there's no ownership interest there. It'll still allow that person to help you, or create a trust wherein one of your adult children is a co-trustee with you. And so as the trustee, they have the fiduciary power to manage your affairs, but it doesn't change their ownership interest in them.
Right. And the other thing is, they can't just clean out the checking account, if they're a trustee, or they'll, if they have a fiduciary responsibility, like with a financial power of attorney, or if they do, they'll be responsible for that. They'll be held accountable for that. Whereas if they're a joint owner, I assume it's just like any other joint account where either person can just take all the money out.
That's right. They could.
All right. That's, yeah, that, especially that's, I think that's really helpful for people. And I really liked your explanation of probate. That's one of the best that I think I've heard, best ways to describe it. So Adam, who do you work with? I mean, we hear a little bit about, estate planning and trust. And I think everyone, feels like that's just for wealthy people. Okay. That they, only need it. But, give us a sense of kind of who you work with, what kinds of people.
So my philosophy from the beginning has always been that I never meet someone that I can't help. Okay. Even if it's in a small way. Look, I could work with anyone. As far as the very wealthy, in my opinion, there are firms, bigger firms, maybe on K Street, that are set up to work with individuals and couples that are worth hundreds of millions of dollars. Could I work with them? Sure, but there are top specialists that are working with those people. I actually get more enjoyment working with people that I can help, what I call on Main Street. Okay, we're talking about younger couples with minor children. They might have good jobs, they're making money, they don't have a ton of money or a lot of investable money, but maybe they will one day, and they just want some peace of mind. If something happens to one of them or both of them, that the money's protected. I'll work with couples that whether they have $100,000 or a couple $1 million, they often have issues to deal with that have nothing to do with how much money they have. Okay, they want to make sure that if they pass away, that money's protected for the kids of the marriage and not for maybe a new spouse that their surviving spouse meets. They want to make sure that all the tax issues are dealt with. And that's not just with the estate tax issues, because the estate tax threshold is very, very high these days, millions and millions and millions of dollars. But what we do want to make sure is that when someone passes away, the investments and the real property get a step up in tax basis for income tax and capital gains purposes. So we're doing some income tax planning. We're doing some asset protection, making sure that your children, when they inherit, not only do you protect them from themselves, maybe with a spendthrift problem. At 18 years old, it's not smart for someone to inherit millions of dollars or even hundreds of thousands of dollars. That money will be spent and it's never coming back. And so we can protect children, even young adult children, from themselves. We can also protect them from their creditors if they hit someone with a car, for example, and they get a judgment against them. And we can also protect them from a bad marriage, making sure that money does not become a marital asset. And there are many, many, many more issues to talk about, but those are some of kind of the highlights of everybody needs help, including that example I gave before of the young couple that wants to make sure that if one of them passes away and the relationship is young, that maybe any significant amounts of money that one side of the family contributed, so whether one of them passes or there's a divorce, that money goes back to that side of the family.
Right. No, I mean, that's great. It really sounds like you take kind of a holistic individual approach to every, person or every family, that you work with.
And even if somebody wants just to come get financial power of attorney and medical directives for now, I'm happy to work with them. We're very relationship focused. I'd rather work with someone, get to know them, work with them for many years, than make any, I'm not trying to get wealthy off anybody. I'm trying to build these relationships and help people and build my practice around meaningful things.
No, that sounds great. And are you able to do that? Obviously, there's a lot of paperwork, legal documents that you have to sign now with, COVID. Are you able to do that, remotely or securely?
That's a great question. And we've been getting that question a lot. So I actually just got off the phone with who I consider to be another top estate attorney in the area, good friend of mine, someone that I've worked on some cases with, and someone asked him that question as well. And it's really hard to answer because, yes, technically there are things in place to allow for remote notarizations on an emergency basis, on an emergency order from the governor. But there's really nothing that beats being in person and having the notarization done in person. because in the future, then you'd have to remember that this was a remote notarization. There's a lot of holes and hoops you have to jump through in order to register with the Secretary of State. You have to use a certain type of video conference. Like we're on Zoom now. It's illegal in Maryland to use Zoom for remote notarization. Right. You have to record that, keep that in the files for the client. It's just a lot of extra work. So what most of my clients have been comfortable with is what I've kind of coined as safe signings. And safe signings are, I'm lucky enough to have a big conference room in our office in downtown Bethesda, so we can stay 6 feet apart. We wear masks, we Purell our hands, and we wear gloves. Sometimes I'll even use a laser pointer to point things out to people from a distance. And people can come in. Often they're happy to get out of the house these days, to be honest with you. And they come in and they sign, and everything is done from a distance. So we do safe signings, and we haven't done any remote notarizations yet, but if we needed to, we could.
Mm-hmm. Yeah, no, that sounds great. Now, how can people talk to you or reach you, Adam, if they have questions about all of this?
Sure. They can reach me by calling the office, 301-986-8600. If they Google my name, it should come up. The firm's name is Bowersfeld, Burton, Hendricks, and Vanderhoof. Don't worry about remembering the name. I'm not even sure my parents know the full name of the law firm. But if you do BBHV, that's Boy, Hector, Victor, and then my name, it should come right up. And also, if you call my office and reach me or leave a voicemail, I'll get back to you.
Sure, absolutely. And for any of my former clients, friends who are watching, if you want to call us at 202-393-3320, we can certainly put you in touch with Adam as well. Well, thank you, Adam. It's really been a pleasure. I think that's been a lot of great information. So I appreciate it.
Thank you for having me, and I'm always happy to share. It's good information for everybody to have, and I look forward to working with some of you watching.